Bill, thanks again for making time to speak to us. Give us a sense of what you made of the particular communique that came up yesterday.
Thank you, Arnold. We saw a joint communication between MTN, Airtel and Stanbic mentioning of a third-party vendor who provides mobile money services to them that had an incident of a cyber breach, and they said that not really so much information was lost. Okay, there's a lot that is to be desired with that kind of communication. One, we are not told who the third-party service provider is, so we are in the blue. We don't know who it is. We are guessing. Definitely in some places, people have read different names, but we want to know who the third-party vendor is and what is the exact extent of the breach. Yes.
If we're to touch on the issue of, two telecom companies coming together and issuing a statement together with an institution that is in the financial space, what does this say? Because if you're to talk to some of the cybersecurity experts, they argue that maybe each one of them should have issued a statement of its own.
Definitely. So if we're looking at a third-party vendor, we're looking at a financial technology company. Then we're looking at Airtel and MTN, those are telco companies. Then we're looking at Stanbic, that is a banking company. So these are different industries, and the far-reaching effects will be a little bit different because of the different data sets that are collected. Yes. So in that kind of regard, we expect them to be able to issue different, communiques and statements telling us of the nature of the incident and the effect it has had on the different data sets that they have, in as much as they operate together in delivering mobile money services to us as the data subjects.
Let's touch on, I want you to just wear your legal hat, because before we came on you mentioned that in the year 2018 there were close to 198 cases that were, or should I say attempts, and only close to 16 of these saw some sort of a prosecution of sorts. I don't know if I'm using the right legal lingo. Just give me a sense of what jurisdiction issues this presents, if at all, wherever this incident emanated from is not even in the East African community.
So let's start with this. The police report of 2018 released 198 cases, and of those only 16 cases made it to court. Only 2 were successful and the rest are still pending. Definitely 2018 we didn't have the data protection and privacy law in place, but now we have one which creates definitely rights of data subjects, that is you and I, and also creates obligations on data controllers and collectors, that is MTN, Airtel, Stanbic, name it. So we have this kind of law now that is providing for different tenets of responsibilities and obligations. Under Section 23 of the Data Protection and Privacy Act, when there has been an incident, the data controller and collector must be able to notify the authority that governs data protection in
this
Uganda.
case, who is the regulator in question?
Yes, this is NITA Uganda. Right. Must be notified, and with that notification, NITA and SAT can work together to see which kind of information must be communicated to the data subject. So we also actually expect NITA to give us some kind of information on what exactly has happened. So now other jurisdictional issues might come in the event that the perpetrators of this incident are not within Uganda, let alone not within East Africa and not within Africa itself. So how do you trace such kinds of incidents? And with the nature of cybersecurity, you might find that the perpetrator encrypted the attack. So how do you begin to move through a dark trace to be able to identify this perpetrator? So some of those issues make prosecution of these cases a big challenge. But I still think post-breach solutions can be put in place to be able to respond to some of these breaches.
Definitely piling us through the dark web there. Finally, just give me a sense of how sound is the act that was passed in 2019. You could maybe just touch on that very briefly and just give us a sense of what could be the best case scenario here with maybe a law in place. The Data Protection and Privacy Act, I think I'm right there. Is it conducive? Does it surmount to something that is binding enough to actually see whoever did this actually face their day in court?
Yes, definitely it is. I think it's a good place to start from, and we can build on from there. But like I said initially, it places rights and obligations, and like under Section 23, it requires the data controller to notify us. So we could even see class actions, you know, and cases brought up by so many people challenging the data controllers in this case for maybe the monies that may have been lost. For now, we have been informed by the communique that there was really no significant loss that has transpired. But in the event that there might be certain class actions that will come against some of these entities. So definitely other issues of cybersecurity could come in, like cyber risk insurances. So we don't know if maybe MTN, Airtel, and Stanbic Bank undertook cyber risk insurance. I mean, these are so many scopes of areas that we could look at to try to find solutions before a breach and solutions after a breach.
Bill, many thanks for making time to speak to us.
Thank you.